catch everybody up, what are you doing these days? Because I know that recently you've had sort of a shift in your career.
Yeah, so Trans-Pacific IP, we're a patent monetization outfit, and these days you could consider that we're doing a little bit more of the NPE spin to things, which is acquiring rights for patents and then trying to license the patents, sometimes through carrot licensing. Unfortunately, that there's you need to have a lot of a heavy stick to carry the day for the most part. But we've done a bit of pivot over the years, moving away from the buying and selling side to just owning ourselves and working on those rights.
Yeah, so you touched on it a little bit there, but you started and spent the majority of your career up until now as a patent broker, right?
That's correct. So I started off as just a patent drafter, worked on filing before the PTO, must have done a couple hundred patent applications that way. Got a taste for being a patent broker through a deal with Siemens, and actually my first deal of any size was in fact selling a portfolio from Siemens to the first NPE that they sold to, which was Trans-Pacific. That's how I got to know Trans-Pacific as sort of the lead buyer in that process. Sold a couple portfolios into them. Very much enjoyed the deal-making side of the business versus just sitting down and drafting applications. That can be interesting too. I'm not going to say that working with inventors and projects can't be fun, but getting the taste of the deal was something I didn't want to go back, so I put both feet into monetization. Joined a small Silicon Valley-based law firm called Tips Group. No relation to the acronym TPIG is what we use now for Trans-Pacific. And just started monetizing patents for clients. Found that there was quite a need back then. All sorts of big companies, small startups looking for cash, small to mid-sized startups that just went bankrupt and were trying to recoup on their intellectual property that they invested in as sort of like a last effort to try to make some of the stakeholders whole. And really enjoyed that. Must have done that for about 15 years or so.
Mm-hmm. So you touched on something I wanted to get at, and you already have introduced yourself as an NPE, or on the NPE side of things, as you say. And there'll be a lot of people who just find that offensive and think that patents that are owned by NPEs are a scourge, et cetera. I mean, you've heard it all, I'm sure.
Yep, heard every comment.
But you just put your finger on, I think, one of the critical pieces here is that when things go south, and inevitably they go south far more often than people succeed. And that's just the American story. That's the American business story. More businesses fail. Yes. And there's just businesses in general, like half of all businesses that start fail in the first year. And 90%, something like 80 or 90% will fail within the first 5 years. So failure is a part of the American business culture. You just dust yourself off and you start over again. But when you have failed and you have assets, then you sell them all, then you give to your investors and the creditors as much money as you can, and you wave goodbye and you move on to what's next. That's a critically important piece of the puzzle for startups, right?
That's a very important piece, and I would even say, going back to what you said about sort of the American system, there's even a part two, is a lot of companies fail, but even those that maybe should have succeeded, that have the bright new idea and have something that they're really pushing towards, other people will just come along and copy them. Say, we have the infrastructure, we have the bandwidth, we're just gonna go and do it better. Now, the consumer benefits in those cases, but often you have these sometimes heartbreaking stories of these guys that really had a good invention, really had a good story, and they just get crushed by the competition because they don't have the infrastructure or the wherewithal to really bring something to market. And going back to your second point, though they need to recoup their losses, a lot of people need to recoup their losses in cases like that. And it isn't even just startups, it's business units within businesses, smaller companies being acquired by larger companies. There's a number of different cases where a lot of investment went into a particular industry or particular niche that then failed for whatever reason. Could have been internal, could have been Could have been the market wasn't ready, or there was just incompetence or in general.
Or it could have been the '08 financial crisis.
Could have been the financial crisis.
And any number of things.
Could have been loans. I've seen a lot of people just lose out, though, through better competition, even though if they were the innovators. And we look at a lot of those type of arrangements.
Yeah. And that's the one thing that I think people need to keep in mind before you start throwing NPEs under the bus. They serve an important role for many innovators, and certainly act in a lot of ways as an insurance safety net for those investors who are putting early money in. They know that they're going to be creating some kind of assets, and it's not there. It turns the game into not something akin to going to Vegas and putting it all on black. If it comes up black, you're great, but if it comes up red, you've lost everything. But when you're funding a startup, you're hoping that there's going to be some assets laying around that in case things go bad, which they usually do, that you'll get some of your money back.
Yes. And the sad thing with you could call them clients or the relations we deal with, is we can't even help them even monetize even a little bit, a large portion of what they had. I wish we could do more. The current marketplace for patents is hard. The judicial system has been grinding it down, as we all know. So what might have had value, call it 15, 20 years ago in the patent space, you just have to, unfortunately, just say very little of what you thought had value still has value. We will do what we can. We'll work with what we can. But the reality is that I'm afraid sometimes you have all these investments that are awash and you can't recoup. And if they can't recoup, they can't invest again.
Right. And, you said that this is good for consumers. I think that's how you put it. It's good for consumers for like one iterative generation of whatever technology is involved. Because so often, and I'd like to get your comments on this, so often I notice that the largest companies are not the ones who are doing the real groundbreaking innovation. There's a lot of reasons for that. Everybody has a role in this ecosystem, and over the last 10 to 15 years, the ecosystem's been out of whack. Risk takers, the innovators, the startups, the SMEs, that's where you see the most exciting innovation because they're not afraid to swing for the fences, and sometimes they actually connect.
Yes.
And the large companies that are publicly traded companies that, a lot of analysts following them on Wall Street, and so they can't necessarily afford to go into these super innovative areas because they will, one, cannibalize what they're already offering, and then two, the risk to failure ratio is just unacceptably high for a CEO who's likely going to be there for 3 to 5 years and then parachute out.
Yeah, as you said, the motivations are not aligned. There's all sorts of reasons for that. Everything you touched on. And if you look at a lot of other countries, I saw this great documentary on Sweden and how every large business in Sweden is like 100 years old. There's no company there that's big that didn't exist 100 years ago. Whereas, in America, if you found the largest of businesses that exist 20, 30 years ago, that would be unusual. You have to have this drive to innovation, but at some point when they get large, they cannibalize their own innovation. The most famous case I know about is with digital film, or film going from digital to film to digital, and where they said, it isn't that we didn't know that the digital revolution was coming. We did. We couldn't do anything about it because it would ruin too many of our sales.
Right. Well, and that's the thing is that they were, the company you're talking about is Kodak, right?
Yes.
And Kodak famously were the inventors of the digital photography.
Yes.
And I've had the opportunity to meet Steve Sasan, who is the inventor, and I asked him, I'm like, how did you have the guts to call this filmless photography? That's what they was originally called. And he looked at me and he said, "Don't you mean how could I have been so stupid?" And we laughed and chuckled. But he was a young engineer. He came up with this, and a lot of other companies made a lot of money other than Kodak on that.
Yeah,
and that's just the way that it goes.
And Kodak saw it, but they couldn't. There was never a good year to eat into their margins high enough to to try to compete in that space. So you see a lot of this innovation, a lot of reasons, and there's a lot of reasons for trying to make money from what you started with. So, and you touched earlier on the saying NPE stands for non-practicing entity. For those that don't know, it's a little bit more polite way of saying other things like patent troll. If you go back to colonial days, they called it patent shark. This isn't a new system. Now, I personally think that the patent troll term should be used for people really abusing the system.
On both
right?
sides.
On both
On
sides.
both sides, right? Because I totally agree with that. Because I think there absolutely are patent trolls who are patent owners. I mean, absolutely. And they're not people like, you don't, they're not involved in a meaningful monetization campaign. What they're involved in is, for lack of a better way to say it, is extortion. Yes. They'll file for $350 or whatever it costs now to file a federal complaint. And if they make $351, they made $1. And they show up and they won't even, a lot of times, have a case go to a scheduling conference because they don't want the judge to even know about the case. And they'll, how about 100,000? No. How about 50,000? No. How about 25,000? No. And so, what about 10? And they'll go down just that fast over the course of a 5-minute conversation. And then finally you get to a low enough number and the defendant say, okay, well, who do I write the check to? Because that check would cost less than my attorney showing up for the motion to dismiss hearing.
Or even talking to your attorneys for the day.
Right.
It'll be less. And yes, there's bad actors like that.
What do you see on the other side too? No, you don't have to name names, but I mean, I see some stuff on the other side. Well, I'll give you for instance. I refer to some of the folks on the implementer side as the hell no lobby. It's like, hell no, we will not take a patent license ever, no matter how cheap you're offering it. And to me, that just, how could you possibly be a willing licensee? Like in the FRAND area, I don't know whether you do any work in the telecommunication, but in the FRAND area, the patent owner has an obligation to offer a FRAND rate. But how can you offer a rate to somebody who says it won't be cheap enough for me to say yes?
Unfortunately, the economics on the other side are just wait, pay nothing, delay. The longer you can delay, the more likely it'll just go away. Mm-hmm. Some of the bad actors, they pick up the rights, they may keep them, they might just evaporate themselves.Ey're not running sustainable business models, in my opinion. So the longer you can wait those guys out, the better. I might do the same thing if I ever go in-house at one of these big companies. Just say, like, let's see the evidence. Show me as much evidence. Let's us sit on it. Let's think about it. Things like that. That's what they do. And if they can, they'll spend years doing that.
Right.
So,
and when I say hell no, I mean, I have a personal feeling for that. I'm frustrated. I identify more so with the creator, the inventor, the innovator, the sculptor, painter, or whoever, the creator. But it's hard to say that behavior is irrational given this legal system that's grown up.
Yes.
So what's the answer? I mean, and I know you're probably not going to have an answer because you and I, we've been friends for a long time and we talk about this an awful lot. But what do you think is the best case scenario? What is the best path to pursue today, 2024, for patent owners?
Well, what we keep trying to do is maybe show some of your cards early. Like, have a reputation, show that you've picked up a good portfolio. This isn't one patent. These are several patents in a good portfolio that have been vetted. Show some of the vetting. Show the claim charts early. Let them know that you're in for the long haul. There's sometimes cases where you use litigation financing. I personally think that has helped the underdog really compete with some of these players, because that whole delay thing they do, you can just drive small businesses into the dust. They can't survive that long. If you can show some financial backing, they should know that you could stand up to this unfair fight and balance it out a little bit more. And going back to showing quality, what maybe I'd like to let some of the public know is just what kind of vetting our patents go through.
So let's talk about that, because and maybe let's put a little bit of a context by it, right? what the folks IP Edge have done in Delaware has cast dispersions on the entirety of the litigation finance industry, I think unfairly, because what they did seemed to me to be just subterfuge, if not fraud. They were the owners. They nominally sold to some food truck operator,
Yes.
right? Literally, you can't make this stuff up.
I don't know all the details, but it gets a little ridiculous. Yes.
And then, but they wound up taking a 90% back end. So who's really the owner in that case? You know, and why did they want to go through this subterfuge to make it look like it was the food truck owner was the owner of the patents that he didn't understand? Wasn't familiar with litigation, didn't know what he was getting into. I mean, it almost feels like to me that's a setup, right? I mean, if you're going to try and make the other side look bad, you'd almost kind of create that scenario, right?
That one, it's hard to comment on until it all shakes out, but there was clearly something weird going on where the judge asked the lawyers, "Who's your client?"
Right.
And they couldn't answer the question.
It's a simple question. You know, you learn that in Ethics 101, you have to know who the client is at all times.
You have to know who you're representing. And so that makes a lot of people look bad. Yes, agreed.
But so now, okay, so we acknowledge that there is that seedy underbelly.
There's bad actors in every field. I don't know how you fix the American legal system in general if there's ambulance chasers in
Right.
one field and tortious interference in another. Like it's endemic to the whole system. So
Right, there's always people out there that are going to try and game any system that they can.
there are.
But like in so many areas of life, it's the small minority that give the majority the bad name. So,
Right.
and I know you're involved in this and now as an owner. You were involved in it as a broker, and you bumped up against a lot of patent litigation financing folks. And I know not all the people that you know, but I know many of them. And I know these are not fly-by-night people. These are not, and they're serious. They were former litigators. They were former executives in large companies. They know the innovation space. They don't throw money around willy-nilly. And they also, as far as I can tell, are not there second-guessing whether this should be settled or take that offer or,
That's right.
So tell us a little
right.
bit about the due diligence, for lack of a better way to describe it, that goes on.
So we start off with our own due diligence. We have a small team. We will look at portfolios, either they're sent to us or people come to us say, can we make some profit from either this subset or our portfolios in general? And we will look through, and without hyperbole, 95% of what we look at, we don't think takes it to the next step. So if we take it to the next step, we commission things like claim charting and prior art searches. We show it to attorneys that we want to work with. The attorneys in general, rule of thumb, are going to be working on some form of contingency model. So they give it their complete review. And often it goes through 1 or 2 or even 3 stages internally to their own law firm to see if they want to work with us on that project. So you think these are really good assets at this point, right? That these are now the 1% of the 1%. Then if we want to work with a litigation financier, they now do the exact same thing. They look through it. Fresh set of eyes, no overlap. They'll see what you did. They'll look at your claim charts and your prior art searches, but they will look at it like just de novo. And if they like it, we're still not done. They hire a third party, independent, to give the whole thing another look over and see if everything continues to check out. So you've essentially had 4 independent professional parties, many of them attorneys, many of them litigation attorneys or patent attorneys that have now vetted and gone through everything to say these have a story, these are infringed, these are valid patents. That's every single case we work on goes through that. And then to sort of say that, you know, we're NPEs have a bad name, it's just wrong. It's improper. That isn't to say that the PTAB doesn't still invalidate patents. Unfortunately, I think the system is quite broken the other way. But that's the vetting process to get to the point where we think that we're gonna try to enforce some rights and try to get some revenue and some licensing revenue from the infringers.
Yeah, it's a long road, and it should be, right? Because these litigation funders who have no skin in the game to start with, I mean, they're looking at an investment opportunity, probably have to be prepared in every case to wait 10 years. Or maybe not every case, but certainly like if you're suing the likes of Google or Apple or, the largest companies, it's going to be a decade or maybe even more.
It's a possibility.
Yeah.
Right?
Yeah. A real, statistically a relevant possibility, not just, this could happen.
Yeah.
So it is, there is a lot that goes into it. And, so where are we now? I've been hearing that the litigation finance market for patent cases has or is in this process of drying up. Is that correct? Greatly exaggerated, some true?
I think it greatly exaggerated. Mm-hmm. There is some truth to it. It was fairly obvious that, like, at one point there was just Burford, right, as sort of the original. Other people gotten involved in litigation financing and patent litigation financing. It was certainly true that there was a bit of an explosion of growth, that you went from having 1, 2, 3, 4, 5, 6 companies to 20 or so. So there were a little bit of oversaturation of the market. And whenever that happens, I think you will see some contraction. You might be seeing the contraction as to the amount of players, but the investors that are out there, they're out there, from what I have heard from public documentation, they have billions behind them. They are still interested in valid, good opportunities. And I have not seen a diminishment of interest from those players at all.
So let's talk about what is a, quote unquote, good opportunity. One of the things that I think a lot of inventors, particularly, the solo inventors, and maybe it should be this way, but it's just not. If you only have 1 or 2 patents, this is not a game that you can really play. No. So maybe comment on that. Usually. And then how many do you need? And if you want to divide it between, overall number of patents and then infringed assets, we can go down that path and talk about that a little.
Sure. I wish just that solo inventor with 1 patent, 1 good idea, got his patent done correctly, could enforce it. The odds are against that. The PTAB, some people have called it a death squad. I guess it depends a little bit on the judge you get even. Yeah. It's you have to probably look at what was the rate of invalidity, about 50%, that if you put a patent to the patent office, the odds of it getting instituted hover around 65%, and then once it's instituted, the odds of it, at least some claims getting validated, hover also, give or take, 65%. So you're looking at close to 50% will be invalidated just by filing for an institution. If you're just looking at the numbers, you might argue that you only file if you think you have the prior art, et cetera. But that's still a crazy high number of patents getting invalidated from the patent office. And these are the patents that people care about. These are the patents, right, that have risen to the top, that are either going to litigation or of a threat of litigation, threat of infringement. We're not talking about the millions of other patents that don't even get that far.
Yeah.
So if you have 1 patent, it would have to knock every other feature out. So you look at the prior art, you look at the claims, you look at the infringement, you look for a divided infringement, right? You look for the story. So you look for a whole bunch of factors. If you have 1 or 2 patents, all those other factors would have to just be shiny perfect to consider wanting to do that sort of 1 patent case. We haven't spotted that yet. Exactly, we've looked. Ideally, you need to have 5, 10 or more patents in the related space that all are good, all infringement, all check out on their prior art searches, so that inevitably when you do the charge of the light brigade, some of the horses are going to make it to the artillery line.
Yeah, and I'm glad you said that. I mean, 10 is sort of the number that I hear a lot, and in order to have a portfolio of 10 solid, well written, well drafted, well claimed, not have real prior art concerns, no eligibility concerns,
Yes,
and infringed.
Oh, the odds of
to get 10 of those, you have to have at least 100 patents, at least.
Well, you have to have hundreds or thousands. Now, that's not to say that you need that every time. You're saying sort of wishful thinking.
Right. I mean, if you think you're going to do this with one patent, because even if that one patent is as good as it gets, as you just said, there's just even at the PTAB, not even talking about the district court or the federal circuit, you have at least the 50-50. I think it's a little higher than that simply because the Patent Office makes it really hard to understand PTAB statistics because they count settlements ahead of institution decisions as a win for the patent owner. And that's not a win that's a capitulation. You capitulated.
It depends. You'd have to see the settlement.
Right. But yeah, I mean, in like Unified, for example, I think they still say this, but they said on their website for a long time,
we don't pay.
We don't pay. We'll take $0 licenses. Well, I mean, if you settle with Unified, that's not a victory for the patent owner.
No.
And then I think it's closer to probably like 80 to 85% of those that actually go through to final decision wind up dying. It probably is in the 50 to 60% range overall. But the other problem you have is you can, like, if you challenge my patents and I win, then our friend Jim comes and challenges my patents. He can do it. Then John can do it. Then Drew can do it.
Yes.
And that's the problem. And I don't know that I've seen really good, reliable information about it. When this is all said and done, after everybody's had their challenge, well, what's the overall invalidity rate? And that's like a multivariable calculus kind of problem.
I don't know. There's not many that have made it. All that way.
No, so you need to have a good number of assets that are infringed, and if you don't, then what do you do? I mean, I say what do you do? I mean, I think a lot of people got away from building companies, and I feel like if you are an inventor and you have a small patent portfolio and you are building a company, then you get looked at differently. You don't know that you should, but I think you do.
Yeah, I think the advice to the small guy is you need your patents in support of a company, in support of an operation. Your few patents, no one's going to knock on your door these days. They did. I've seen cases 20 years ago they'd knock on your door, look to acquire it. The current marketplace, no one's knocking on your door and saying, here's a big bag of money for your patents. I don't care if you have a business or not. I personally don't see much experience. I see a lot of inventors asking for that sort of thing, but it just doesn't happen.
Yeah, no, it doesn't. So, and I think luckily, by and large, the path that you would go on to start your own company and build, or whether you're doing manufacturing here or you're doing it overseas and importing in, all of that stuff is going to inure to the benefit of the patent portfolio as you're growing the company, and maybe the whole company gets acquired, or now you show the value. So maybe your goal is not to, like, 10, 20 years from now have a company and you're CEO, or you've hired a CEO and now you're the founder and chief, or chief technology officer. It happens a lot of times because the inventor was the CEO, was the only person for a while. If you're going down that path, it's going to pay dividends anyway.
Yes. Yeah.
Yeah. So what are you bullish or bearish on the market? First off, define the market however you want. Maybe we could talk about it from the patent owner's perspective, and then maybe the innovation marketplace more general.
Yeah. I'm generally bullish. We've talked about the validity of patents, you and I, a lot over the years, and like anything in law that they teach you in the start, there's the swinging of the pendulum, right? Where Was it in the 70s?
Yeah.
There was no valid patent, and then the pendulum swung, and we seem to have swung back. Is it as far as it's gonna go? You have to start recognizing that business methods and quote unquote abstract ideas, are patentable. There's a lot of innovation that takes place because of what we're doing on computers, because of self-driving cars and other things like that are, in my mind, of course they're patentable. You have hundreds of millions and billions of dollars going into research to try to solve these problems, and they should be patentable. So I think that the patent system can only catch up from here, because I think we've gone as invalid one way as we're going to get. Now, when more patents are valid, then of course, if you're an NPE, you're doing well. But as the original stakeholders, you can then monetize. You can make money from a lot of your early inventions for whatever reason that we discussed. And so I am bullish in the long term. These pendulums move very slowly.
This one's moving very slow.
This is moving.
It almost feels like it's stuck. That there needs to be something to release it. That the pendulum got caught up on one end of the swing.
It's over here, and maybe it'll start swinging now. I can't see it getting much worse without drastically hurting innovation in the whole economy.
Yeah. And I keep thinking to myself that eventually Congress will figure this out, that if you want to really unleash innovation, you have to have policies in place that will benefit the risk taker.
You have to, and you see it time and time again in industry after industry. There's a famous case in South America where they wanted better health care, so they wouldn't allow protection around health care, and they ended up with worse
with no health care, probably,
because no one would go in and take the big risky steps or the big investments. And you sometimes hear it thrown around that NPEs, patent trolls, they kill innovation, but the opposite is proven to be true. When you can protect people's rights and they know that they can get some money for their assets, you do better. And it's like the property market. Are you only allowed to own property if you agree to live on and farm your own property? Right. Could you imagine what that would do to the property market if that was the metric?
Right. That would be great for family farms, but it would be disastrous for the food production.
That would be great for family farms or communist societies.
Yeah, but the government just seems to completely lack the ability to understand how people are going to respond. They see something, they don't like it. Well, we'll stop that. And I always refer to it as the third grade way. I went to Catholic grammar school. And we would get up a couple times throughout the day, and they prayed us all down to the bathroom so we could all get a drink of water and use the bathroom. And for whatever reason, we weren't allowed to talk. Probably, there were other classes going on or whatever, but you couldn't talk. So if somebody talked out of turn or was wisecracking, then the whole class lost recess. And it's like, it feels to me that that's what the world we live in. It's like, you damn dirty rotten scoundrel, patent troll, we're gonna kill you. And so we take out an elephant gun to shoot the patent troll, and there's a whole lot of things that get in the way, rather than some kind of surgical strike to get at the bad actor, who we can all agree with that we don't want that.
Yes. No, agreed. And you see it in a lot of industries. My property example before, when you get these cities that say rents are too expensive, so we're going to institute rent controls. And 10 years later, they have a much worse problem. Yeah,
less rentals. And the rentals they do have are falling apart because you can't invest in upkeep.
That's right. You tend to get, things aren't always intuitive. Just saying, hey, here's the bad actor, here's the bad situation, here's what we're trying to fix. And in the middle of COVID, there was a long discussion of whether or not you don't allow any intellectual property rights on the COVID. There was people in the industry saying, just wait a minute, we're not at the end here. We have years to go on vaccine developments or the next treatments or whatever, or even the next pandemic. Like, you can't just say, we're frozen in time we're going to fix this situation and pretend the Earth doesn't roll forward.
Yeah,
So,
and that was always, I mean, that was a farce, right? Because, like they kept saying that the only reason that we have these vaccines is because government paid for them, and and it's like, no. If you actually looked at that particular mRNA, I mean, the first patents, because I looked at this, the first patents were filed by Johnson & Johnson back in like 2002, 2003,
yeah.
which are 17, 18 years before the pandemic even started. And then they continue moving down that path, and a lot of people started moving down that path way before. I mean, yeah, there was this catastrophic event that then caused government to swoop in and get manufacturing in order, faster approvals from the FDA and all that sort of stuff, cut the government red tape. That was good. I don't want to say government didn't do anything. I think government did the responsible thing at the time.
Yes.
But they wouldn't have been in that situation to do the responsible thing had it not been for companies like Johnson & Johnson and others investing almost a generation earlier.
Yes. 20 years earlier, you have companies that say, let's invest in the next generation of technology. And then when it's needed, and suddenly it gets taken away. Like that,
right,
none of that makes sense. But nothing looked at through just a small lens makes sense that way either. So
no. And one thing, and you don't play in the AI space, do you? You're not involved in that.
No.
So, but one of the things that came up in my mind when you were talking, and I kind of, we do an AI program. AI is a part of a lot of the programs we do because it's the future, right? There's a lot of tools in the IP space. There's a lot of excitement about generative AI, and then there's the old school AI, not necessarily generative, but extremely powerful, lets you do all kinds of wonderful things, right? I've never bought into this whole debate that people just, they lose their minds about it and get so passionate about it. Can AI be an inventor? Should AI be an inventor? And whenever I hear that, I kind of roll my eyes, and it's not that I don't think it's an important question, but I think I just figured out why. Because what went in my mind when you were talking about, some of these things just aren't eligible. We have to abstract ideas and things we got to figure out. They are valuable. What kind of irony is it that we are debating whether AI can be an inventor itself, when in fact much AI can't be patented? So the human who created the AI, you're screwed, pal.
yeah.
But hey, AI that came up with something after somebody created the Star Trek computer, the all-knowing computer, well, the machine, we'll let the machine be an inventor. It's like,
Yeah, you're missing a step.
It's like to talk about jumping the shark. Like I just feel like it's and it's not that it's not a worthwhile or important conversation. I don't mean to upset anybody who really is into that conversation, because I think it's fun to talk about, right? I mean, because we all grew up, or a lot of us grew up reading Isaac Asimov and the Robot series and Foundation, and then other science fiction about robots, and then about artificial intelligence, and is going to take over the Terminator, going to take over the world, HAL, 2001 Space Odyssey, all these different things, right? And so it's interesting, and it's been a long time coming, and I think that's why people get excited talking about it. But it's like, let's dial it back a little bit. Let's figure out the easy stuff first, because we're struggling with that.
We're struggling with new inventions, new things. AI, we're in a spectrum with it, but it's a tool, just like any other tool. If there's inventive steps in there, just because they're all on a computer, inventive steps need to be protected and able for protection. There's companies that are worth trillions of dollars now just because of that, and they're competing. Should there be protection there? There should, in my opinion, right? And a lot of these steps in AI should have protection. Now, whether or not it's AI as the inventor, I personally don't think so. It's a tool, right?
Right.
So it goes back to whoever is using that tool.
I agree with that. And I had an argument with somebody the other day. I was speaking on a program. It wasn't really an argument. And they kept trying to get me to see their perspective. I said, look, let's stop. I agree with you. I'm just explaining to you what the law is. Right now, the AI can't be an inventor. It could be a co-inventor. And how screwy is that? That it can be a co-inventor, but it can't be an inventor. And the reason is the rules don't allow it. You have to be a person to be an inventor. But the a person doesn't seem to apply to the co-inventor. And it's because nobody ever thought of it, right? If they had thought about it, that would have applied that to the co-inventor as well.
Yeah, but I'm not sure how that works.
It's just bizarre, is the way the patent rules are written. So that's why people are talking about it being a co-inventor. And it's just, but the fact that we can't reliably protect AI right now, or the other thing that frustrates me a lot is the patent was drafted to satisfy the rules of the Federal Circuit when it was filed. And then 10 years later, when it gets litigated, it's like, oh, well, we've moved on. You should have done it this way. Well, I would have if you had told me 10 years ago that I had to do it that way. We could have done it that way, but now it's too late.
Yes, that's terrible. It really is. It's such an unfair retroactive punishment. There should be some allowance for it, but either that or just stop changing the rules so often at the Federal Circuit.
Right,
might also be helpful.
Yeah, that's it. It's frustrating. I don't know what the answer is, but it is frustrating to watch the way that the Federal Circuit and I just and I laugh, and we've had not arguments about it, but you've had one of these. Let me just explain to you the way the law is about venue. Right? Mm-hmm. And because I go off on the Federal Circuit, I was like, look, where the server sits probably should never have mattered, but I'm willing to say that, okay, in the 1980s, when personal computers were a new phenomenon, factoring that in maybe made some sense. But now in 2024, where everybody is connected, everybody that wants to be connected is connected. It doesn't matter where the server sits.
No.
And in fact, you have all these CDNs that move copies closer to people, like when you're talking about internet technologies for one, or downloading things, for example, so that it gets closer to them so that they can download. So these things are everywhere.
Well, I think if you go back a year, you might find our video talking about venue, right?
Yeah. Right.
Yes, I agreed. I personally can't see putting that much onus on where the servers are. So it just doesn't make sense.
It doesn't make. I feel like, well, I've actually started hearing people, and I haven't said this myself, so that I know that this is not me starting this, but I've started hearing people say that we need another like 1952 moment to sort of straighten this whole thing out, where we recodify the patent laws and kind of start fresh with an eye towards the digital reality that we live in. What do you think? Do you think we need that, or is it salvageable within the framework we have now?
From what I can tell, the broken parts we have from people smarter than me is the courts aren't going to fix it, as we kind of need to get Congress or to the lawmakers to just do a few fixes here. And then, of course, other things might end up being broken from whatever the fix is, like the last time around. But again, the messaging seems to be that we need new legislation.
Yeah, I think we do, and I don't think it can happen fast enough. And whatever legislation we get, if we get any out of PARA and Prevail and what I continue to be told is soon to be introduced, that information I've been told is soon to be introduced for at least a year now, the soon to be introduced bill that will overrule eBay. Even if we got all of that, which we won't, and even if the eBay bill ever gets introduced, which it probably won't in this climate, but even if we got all of that, it still wouldn't address the real problems with obviousness. That you see, the irony I see is we talk about things that are extremely high tech, like NASA, JPL, like really futuristic stuff. The threshold for obviousness is off the charts. you talk about like a kitchen gadget that you can buy on QVC, or you might see a tool in Home Depot or Lowe's. And it seems like the obviousness threshold is like, oh, well, that wasn't ever exactly done, so it must be patentable.
Yeah, you see that the most cutting edge stuff on the planet. In hindsight, we're going to throw together 3 references that never even existed in the same space before. Out of millions of references, assume that the inventor would have read those particular 3, and that was then obvious to anyone else. It's not a fair. I've always thought the hindsight standard was a little bit too biased, a little too easy to get around, and it hasn't gotten easier or nicer.
No, and I also think that a lot of what's going on with particularly independent inventors and really small companies that get patents, they don't know the system like we do. They don't know that in certain areas the examiner will give you anything you ask for, whatever you ask for, or close. And then in other areas it's virtually impossible. So they get a patent issued and they think, well, the examiner reviewed it, it must be good, I know it's unique.
Yes.
Because a lot of them, they may not be sophisticated in the law, but they're very sophisticated in what it is that they're doing. And they know that it deserves to be patented because there's nothing else out there like it.
Yes.
And they got a patent, so therefore it's good. I can invest in it. I can do these things. I can start making money in it. And then when the rug gets pulled out from under them, they feel like it's been stolen away, which, of course, it has. But I think with some of them, they should never have gotten the patent in the first place in this overly permissive patent office that allows almost 100% in certain areas is partly to blame.
They are, and it's not fair to spend the money. Now, the patent office gets whatever thousands of dollars, and the attorneys working for the inventors get, call it $10,000, $20,000. But the patent office themselves, they're getting, what, $3,000. And so when this gets challenged by a real challenger, they might put, what, $100,000, $1 million behind invalidating what the patent office spent $2,000 to see if it was good. There has to be a little bit more done, I think, on the quality. And I don't think
or nothing. I'd be okay if it was nothing, right? Because I think you're exactly right. I mean, it feels like the patent office is playing the role of an arms dealer. I'll sell you a patent for $5,000, and then I'll sell you the right to kill that patent for $100,000 or $1 million or whatever.
It's the mafia in some regards.
It is, and it's not right. I mean, so I would think a rational solution would be to do more on the front end to get more of them correct. Another rational thought would be let's just on the very front end, let's just look at novelty, and if this turns out to be one of the 2, 3, 4% of patents that are going to make people money, then we'll figure out on the back end. I'm not sure I'd be in favor of that, but that would be a rational system. What we have is the worst of both, where you're going to spend tens of thousands of dollars on the front end, in some cases over the span of 4, 5, 6, maybe even longer number of years. And then on the back end, if you make money with it, you're going to have a all expense paid ticket to litigate this at the PTAB. That's going to cost you at least $300,000. And if it's really valuable, it's going to be closer to $1 million.
Yes. Yeah. It's too little on the front, too much on the back. Yes.
Right.
Agreed.
And I don't know what the answer. I mean, that's why I think I do like the idea of. I'm a little hesitant, but I think we do need a 1952 moment where we shuffle this up and say, okay, that path makes sense in the law. This path doesn't. Let's rework that. And because these things don't fit together anymore. The problem with that is the same problem with people who want a constitutional convention. Is like, well, you want a constitutional convention because of one thing, but if you open up the Constitution and everybody gets their say, then you might wind up being less happy in the long run. That's the negative thing. And in this climate, I don't know that I would feel comfortable with rewriting all of the patent laws the way we did in 1952.
I don't, unfortunately, have a good answer for you there, other than we need some legislation to, I think, fix and protect things better. Or maybe we just start with what you said and start allocating a little bit more resources on getting the good patents out first. That I don't know anyone that would argue with that.
Right.
But then we need better protections for what we do. We need to protect more of what's important to the economy. Mm-hmm. So there's a lot there.
Yeah, there is a lot there. And I think there's any number of things that could happen that would be, I don't know, an instant fix, but would shake things up in a very positive way. Some reform for eBay, and we're never going to go back to the days, and people always throw this as like, well, so you want an injunction so that the pharmaceutical company, when they win, could force these drugs out of hospitals and somebody who needed it the next day would die. It's like, okay, that's not going to happen. I mean, any idiot could figure out how to write an order that would ease the infringing product out of the marketplace over time as the patent owner can replace it in areas where there's real public health or public need. It's the parade of horribles that just, it gets thrown around, and I don't know. And I guess, I'm stammering and stuttering because I keep getting frustrated by, for whatever reason, and maybe this goes across the board, but having the bumper sticker that is anti anything is easy. Like we both live in the greater DC area. You saw during the pandemic all kinds of billboards. I'm sure you did. Patents kill.
Yeah.
Okay, that's an easy bumper sticker, right? The narrative as to why patents are useful and good and do better and create innovation and lead to a better society, that's a paragraph.
It's harder to grasp. It really is. It goes back to my analogies. Like, why are landlords bad? Why are property owners easily vilified? That's because you don't actually get the economy based around these things, and unless the behind the scenes incentives are there, and the behind the scenes incentives are not obvious to people just looking at things casually.
Yeah. So we've been going for a little bit. I really appreciate this. I want to kind of just wrap it up, and maybe I'll throw a question at you. I've already asked you. I asked you if you were bearish or bullish, and at the end of this conversation, are you bearish or are you bullish?
Well, I must be bullish because I'm getting deeper into the whole environment and the monetization of patents and sort of the ecosystem behind it. And I'm still bullish because I can't see that pendulum swinging so much more to the other side. There has to be a protection of property rights, or you don't get the investments behind them. So
yeah, I have to be bullish myself, right? Because I couldn't get out of bed to do what I do if I wasn't bullish. But, sometimes when you talk about all these problems and you lay it out, it just feels so daunting that I don't know where the end of the tunnel is. Sometimes I think the tunnel may be so long that I don't see the light, not because there's not a train coming, but the tunnel is so long.
It is. It's very long. Still bullish. Still, there's a market behind patents because there's a market behind good inventions. So, and I believe that.
Good. Well, that's probably a good place to end. I really appreciate this conversation. Thanks for coming.
Thank you, Gene.
And thank you all for listening. We'll see you soon.